5. So this is part 4 of your notes in Unit 1. Here's Chapter 5, talking about the court system here in the United States. A little bit about the trial courts. That is where you listen to testimonies when people are up there talking, answering questions. They're looking at evidence that's presented, and then they're deciding the facts in the situation. There's sometimes a jury that's involved. When we're talking about civil and criminal, again, what is the difference between those two? In a civil case, the party bringing the case is called the plaintiff. It's very important. So that's a lawsuit. Someone's suing someone. And in a criminal case, that person is the prosecutor. So that person works for the government. So the prosecutor is bringing those charges and representing the country or the government in court. Adversarial system is allowing opposing parties to present their legal conflicts before an impartial judge or jury. So the judge and jury are sitting there. They're not supposed to pick a side until they hear the evidence that is presented, and both parties are kind of going back and forth. The inquestional system is a method for handling disputes in which the judge is active in questioning witnesses and controlling court processes. That's a little bit different. That's some other countries use that where the judge actually asks questions. So what does the judge actually do? They preside over the trial. They're the ones that are following the rules, make sure the attorney follow the rules. They tell the jury about the processes and the procedures and the law. So this is the law that you're looking at. Did they violate it? And then after the trial, if someone is found guilty, they actually sentence that individual. They get to choose within the parameters of how long, maybe a jail sentence, probation, things like that. Another part of this system is the jury. Individual can be part of the jury if they're 18, U.S. citizen, a resident of the state. They must speak and understand English as well. And that's part of your 6th and 7th Amendment, the right to a civil and criminal trial, and they can have a jury. So you can serve as a jury member, and the way you can do that is by being a registered voter, having a driver's license. Your name gets thrown in there, then you have to go to jury service, jury duty if you are called. They'll mail you a letter and tell you, hey, on this day you have to show up and you might be picked as a juror. Convicted felons are ineligible for jury service until maybe their rights are reserved or restored. For juries, employers are required to give you time off. So if you are called to jury duty, they can't fire you because you're missing work for that. Sometimes the courts pay jurors a small stipend. It's like $25. Other times you have to give that to your employer. The employer will say, yes, you can go to jury duty. We're going to pay your full salary for that day. You just give us that $25 check. One day, one trial plan. Jurors usually show up for the day. If they're called, then they're selected that trial. If that trial goes for a long time, then they're there for a long time, for months if possible. Usually it's only about a week. When we're talking about jury system, the voir dire system, that is the screening process. So when jurors are in there, they sit in the jurors booth, and the lawyers ask questions, both sides, and they pick out which jury members are going to favor them the most. There's two ways to get rid of jurors then: the removal for cause. Opposing attorneys may request the removal of any juror who appears incapable of delivering a fair trial. Like if someone says, I hate cops, well, the prosecutor is probably going to want to get rid of that person. Or I hate the law, this country's the worst, something like that. So there's a cause there. Preparatory challenge. Attorneys on opposing sides may dismiss certain jurors without a reason. They just can look at a person and say, I don't want that person. But you cannot base it on race. In our court system, we have an appeal system. So if you go through one trial, you might appeal that case. You didn't like the outcome. Maybe something you thought was wrong. So in the appeal system, they present their arguments. There's no juries, no witnesses, no new evidence. They just kind of present the legal evidence again and show that maybe one of the sides did something wrong. Okay, it's only possible if there's a claim that there's an error in law. Appeals courts kind of set a precedent. That's a very important word. A court decision that guides future cases. So if there's a similar case, they might look at an old case and say, you know what, this is how we determined it. This is how we're going to do this again. Then there's different opinions of the courts, and that's called the majority opinion, which is the outcome. So the winner of that outcome is the majority opinion. There's 9 justices on the Supreme Court. You need at least 5 votes to win. The dissenting opinion is the losing side, the other side, written by judges who disagree with the majority. And there's also a concurring opinion. Those are the judges that agree with the majority, but there's some other reasons why they agree, so they write those down. If you take a look at our federal court system from the bottom, your district trial courts are the lowest. Then there's the appeal courts in the middle, then your Supreme Court, and that's very similar to what we have in Illinois. Circuit courts are where all your trials are at, the appellate court where the appeals occur, and then your Supreme Court. Your federal court system, Congress has the power to create those federal courts and lower courts. 70% of the cases are boring, like bankruptcy cases, but they hear about 1 million cases per year. Tribal courts we're not going to really get into. Again, those are on Indian reservations, and they have authority over those. Your Supreme Court is 9 justices on the Supreme Court. All courts in the U.S. must follow any decisions that they make. They're the highest court. That's why it's interesting. When they make a decision, everyone has to follow. It's kind of like a law. Majority of those cases that are appealed to the Supreme Court are prison inmates. They're saying this is something that happened. This was wrong. We need to hear this. You need to look at this case. Sometimes old Supreme Court cases are reversed because society has changed. So, for example, Plessy versus Ferguson said it's okay to segregate individuals on a train of a car or a car of a train, and Brown versus Board kind of reversed that decision, said separate but equal is not right. You have to have inclusion there. So the Supreme Court process, what they do, they hear a case, both sides write briefs about the case, so they look over those. There's oral arguments, so each side gets 30 minutes to present their case. Then the justices or judges go in a secret room or a private room, discuss it, then they write up their opinions and they vote on it. What they do, they work from October to June. After those, then they write them up and the decisions come out. For example, the decisions came out in like July for the last session. Justices get their job because they're nominated by the President of the United States, they're confirmed by the Senate, and they have that job for life. There's your current Supreme Court. And then we're not going to really get into international courts. Okay, so that's chapter 5. And then if you look at chapter 6 here, we're talking about lawyers. So lawyers, they are called attorneys, and they're the litigators, possibly individuals that are going into the courtroom and kind of making their arguments. Okay, so they make their arguments in front of people, but lawyers as well are working in businesses and writing contracts and doing real estate, and they're in family law. So lawyers have a lot of different things, but the lawyers that you guys know, trial lawyers, are called litigators. Those are the ones that are on TV that you guys see, and they're arguing and presenting evidence and trying to convince the jury. So why would you need one? Again, like I said, there's real estate, divorce, adoption, contracts, accidents, all those different things. Legally, you need someone to represent you. In the past, lawyers could not advertise, but now they can. So they can advertise for their services. But you want to ask someone for a recommendation. You want to look around, look for someone that maybe could help you defend yourself, or maybe you have a lawsuit that you need to handle. Legally, in a criminal case, if you can't afford one, a public defender will be appointed to you. So what do you need to ask when you're looking for a lawyer? How much does that person cost per hour? Is it per text message, email, contact, meeting, call? All those things, they might come to effect. They can get very expensive. There's a retainer fee, possibly, or a down payment, because they want some money up front so that you stay with them. There's also maybe a contingency fee per hour, or a lump sum, a percentage maybe of what you win. So you're going to sue someone for, $300. They want a third of it, so they're going to get 100 of that 300. And then working with your lawyer, you must be able to trust your attorney. Again, there's a privilege there, kind of like a doctor. A doctor can't tell everyone about your medical history and things like that. A lawyer has to keep that information confidential as well. They can give you advice, but they can't make the final decision. So if they say, you know what, you should plead guilty here, you don't have to. It's all completely up to you there, but they are the legal experts, and they're going to try to give you advice. Then the last thing is the type of lawsuit brought against someone or against a lawyer for loss or injury of the client caused by the lawyer's error, failure, to meet acceptable standards of practice for the legal profession. That is called legal malpractice, and you may lose your license as a lawyer if that happens. So that's Unit 1. That's Part 4. Last two chapters there, Chapter 5 and 6.